All right, court calls the cases of the people of the state of Michigan versus Alan John Madison, case numbers 24804 ST and 24865 ST. We're here for arraignments. Mr. Madison, I know you signed the waiver of conflict. Did you have ample opportunity to discuss that issue with Mr. Hartel?
Yes, I did, sir.
And are you, I see you signed it. Is it your desire to then have me sit on this case and hear the case?
Yes, sir.
Cases? All right, I have signed those conflict waivers then, and we will move forward. In case number 24865 ST, I have a complaint that alleges that on or about March 28th, 2024 in Clam Lake Township of Wexford County, it is alleged in count number 1 that you committed the offense of operating while your license was suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. In count number 2, it's alleged that you operated a motor vehicle without insurance. That is a misdemeanor punishable by up to 1 year in jail and or a fine of not less than $200, but no more than $500. In case number 24804 ST, it's alleged that on or about March 17th, 2024, in the city of Cadillac for Wexford County, that you did in count number 1 commit the offense of unlawful use of a license plate. That is a 90-day misdemeanor and or a fine of $100 unless it's a commercial vehicle, then it's $500. Operating without insurance, again, another 1 year misdemeanor and or a fine of not less than $200 nor more than $500. And in count number 3, operating while your license was suspended, denied, or revoked as a second or subsequent offender, which again is a 1 year misdemeanor and or a fine of $1,000. Do you understand those charges and the potential penalties?
Yes, sir.
He was not picked up on the warrant, right?
I think he's the one who called us.
I turned myself in.
Okay, all right. The court will go ahead and cancel the bench warrants then. Mr. Madison, what is a good mailing address for you?
912 1/2 North Mitchell, Cadillac.
How about a phone number?
231-884-2364.
Do you have an email address?
YU Madison MATTISON @gmail.com.
All right. And I see you sitting with Mr. Hartel. Did you have the opportunity to discuss the arraignment before coming in
Yes,
today?
sir. He does not represent me today.
All right. So you do have the right to be represented by an attorney in all phases throughout this process. And if you decided that you wanted an attorney but could not afford one, you can request the appointment of an attorney. You just may have to repay a portion of that expense. Do you understand that?
I do understand.
And it's your desire to, you said you didn't want, Mr. Hartel's not representing you today. So do you plan to represent yourself or hire an attorney?
I plan to represent myself.
All right. So today you have a couple of options available to you. One would be to plead guilty to the charges. If you pled guilty, 5 misdemeanors would enter on your record and you would be sentenced today. The other is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial, which would give you the opportunity to discuss the case with the prosecutor to see if there's a way to resolve it short of going to trial or pleading as charged. Do you understand those two options?
Yes, sir.
Today, then how do you plead, guilty or not guilty?
Guilty.
All right. Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in these matters will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Madison, back on March 17th and March 28th of 2024, were you on probation or parole?
I do not think so.
All right. Do you recall whether you were on bond at all?
No, sir.
Do you understand that you have a right to a jury trial in each one of these cases and that by entering a guilty plea today, you'll be giving up that right to have a trial and you won't have a trial of any
Yes,
kind?
sir.
Has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead it?
Yes, sir.
Mr. Carnes, are you aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
Then Mr. Madison, to the allegation, we'll start in case number 24804. That on or about March 17th, 2024, in the city of Cadillac of Wexford County, how do you plead to operating a motor vehicle with an unlawful plate?
Guilty.
To operating without security?
Guilty.
And to operating while your license was suspended, denied, or revoked as a subsequent offender?
Guilty.
In order to accept those charges, I must have you tell, or I'm sorry, in order to accept those pleas, I must have you tell me what it is that makes you guilty. So back on March 17th of 2024, were you operating a motor vehicle in the city of Cadillac?
Yes, sir.
And was that plate on the vehicle not registered to that vehicle?
Yes, sir.
Did you know that?
No, well, I probably did, yes, sir.
What do you mean by that?
I believe it was my girlfriend's. I transferred it from one vehicle to another vehicle. My girlfriend, we sold a vehicle and I put it on that vehicle.
And when you say you transferred it, do you mean you just put it on that vehicle?
Yes, sir.
You didn't transfer it through the Secretary of State?
No, sir.
All right. And it is also true that that vehicle did not have insurance.
Yes, sir.
Did you know that it didn't have insurance?
Yes, sir.
And it is also true that you were operating while your license was suspended, denied, or revoked?
Yes, sir.
And did you know that it was
Yes, sir.
suspended, denied, or revoked?
Yes, sir.
And do you have a prior conviction for that back from here in the city of Cadillac from January 14th of 2020?
Yes, sir.
Mr. Carnes, do you believe the defendants provided a factual basis in which to accept the plea and the court rule has been complied with?
Yes, Your Honor.
As does the court. I find in that case, the defendant guilty of counts 1, 2, and 3. Now moving to case number 24865.
Which was only like a week later. Same
Yep.
thing, sir.
Okay. So to the allegation that on or about March 28th, 2024 in Clam Lake Township of Wexford County, how do you plead to operating where your license was suspended, denied, or revoked as a second offender?
Guilty.
And to operating without insurance?
Guilty.
Your Honor,
Yes.
given how he's going through everything, I'll dismiss the no insurance on this one to try to keep the fines down a little bit.
Okay. All right. Mr. Madison, I assume you're all right with that?
Yes, sir.
Okay. Has anybody, other than this plea agreement that we just discussed, has anybody promised you anything in this
No.
case? Has anybody threatened you in any way?
No, sir.
And is your own free choice?
Yes, sir.
So I assume then that you were operating this, looks like the same motor vehicle,
Yes, sir. It's a Dodge Durango.
and you hadn't gained your license in between
No, sir.
time? And it is also true that you were convicted of the same offense back on January 14th of 2020?
Yes, sir.
All right. Mr. Carnes, you believe the defendants provided a factual basis to accept the plea in this case?
Yes, Your Honor.
As does the court. Mr. Madison, I find you guilty of operating while your license was suspended, denied, or revoked as a second offender.
Yes, sir.
Pursuant to the plea agreement, the operating without insurance will be dismissed. Mr. Carnes, any elocution?
I might have a second, Your Honor. I lean earlier, it doesn't appear, I know he has at least one prior, and he does have a prior no insurance. But it looks like 2 prior DWLS, one prior no insurance. Really, this is a problem. Mr. Madison needs to get legal or needs to stop driving. Certainly needs to stop driving until he gets legal. I'd ask the court to take into consideration those priors during sentencing, but I also ask the court to take into consideration if he did turn himself in as a bank cooperative. Thank you.
Thank you. Well, Mr. Madison, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
I'm guilty of everything that's been here. The only thing I can add is I do have a disabled partner at home. I'll take all the fines you can throw at me. Just keep me out of jail if you would. I'm working with the VA right now,
Okay.
trying to help me. They'll help me with probably my court fines and everything, help me get my license. They're helping me with my housing situation right now.
Do you know what you need to do in order to get your license?
Not exactly. I'm gonna go to the Secretary of State and have them print out what I need so I can give it to the district attorney.
When was the last time you had a license?
Probably 10 years ago, sir.
Okay. All right. So,
My problem stemmed back before I moved to Michigan.
okay.
Can you date that under hers? Or do you want right now?
I'll just cross it out and sign.
Okay.
So do you remember what was going on these days as to why you were driving?
On them days, yeah, I just started a job at Viewer Sawmill in McBain.
Okay.
And both times I was driving home the back way from McBain to Cadillac, and I got pulled over.
Oh, when you say the back way was at McBain Road?
Yes,
Okay. How long have you been working with the VA?
off and on for probably 6 months, but recently the last week. And that's because I've been looking for a job since I lost my job at Viewers. And they determined that I'm not finding work because I have a warrant.
Okay. And then is it my understanding that the VA helped you get brought in today?
Yes, sir.
All right.
They suggested that I come in, try to get my warrant lifted so I can get a job.
So why had you been missing for so long?
I'm sorry.
Why were you missing for so long and not coming back to court?
I've been looking for work for the last 6 months.
Okay. All right. And so you're unemployed right now?
Yes, sir.
Are you receiving VA benefits?
No, sir.
All right. Are you receiving any type of
No, sir.
assistance?
No
Anything-
unemployment, nothing.
Okay. Anything else you'd like me to know?
No, sir.
All right. I'm going to keep fines and costs to what I absolutely have to in both of these cases. There is a $75 Crime Victims' Rights Fund fee. This is an 804. $75 Crime Victims' Right Fund fee, 3 $50 state minimums. And a $200 fine for the operating without security. I'll waive the court costs. In case number 865, again, I'll keep that to the minimum that I have to order, and that is a $75 crime victims' rights fee and a $50 state minimum fee. Mr. Madison, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that.
Yes, sir.
Now, also, because the offenses that you've been charged and convicted of require that your fingerprints to be taken,
Okay.
I have signed a fingerprint order for each one of those cases.
Okay.
When you're done here, you'll need to go out to the front window where you checked in,
Yes,
get a
sir.
copy of your judgment, make a payment or get set up on a payment plan, whatever you need to do there.
Okay.
And then also get copies of those fingerprint orders, and you'll need to go to the Wexford County Sheriff's Office
Yes, sir.
to get those prints taken.
Yes,
Now,
sir.
you have to have an appointment. You can't just stop in.
Okay.
And make sure you do that, because if you don't, one, you'll be in violation of the court's order.
Get a warning again.
And, well, not necessarily, but also, your criminal history won't be complete. So it'll just show that these charges are just hanging out there with no resolution. So
Understood.
just make sure you get those taken care of.
Yes, sir.
Do you have any questions for me at all?
Sir, and thank you.
All right, thank you. Good luck.
Thank you. Thank you, sir.
Person at the jail, please state your name for the record.
Christy Terry.
This is case number 26215 SM, the people of the state of Michigan versus Christy Lynn Terry. We are here for, looks like it's going to be an arraignment on a bench warrant and also a show cause for bond violations. Ms. Terry, it's alleged that in the show cause that you failed to appear for a drug test as ordered on February 1st, 2026 as a condition of your bond, and also that you failed to appear for a drug test on February 3rd, 2026. Again, a violation of your bond. You do have a right to have a contested hearing in this matter, where the prosecutor would have to prove to the court that you did in fact violate your bond conditions, or you can plead guilty to the bond violations. Mr. Hartel, how are we proceeding today?
Your Honor, we would ask for a contested hearing.
All right, the court will set the matter for a contested hearing. That brings us to bond then, Mr. Hartel.
Yes, Your Honor, I'd ask the court to consider allowing her to be released pending that hearing. I do realize these type of requests are an uphill battle, for perhaps obvious reasons, but for what it's worth, without going to anything protected by attorney-client privilege, I did have an opportunity to meet with her a bit earlier today. I do believe she has every intent to stay in contact with my office. She knows that any of her needs that our office social worker, Mr. Brian Henniger, could help her with, perhaps to make it easier for her to stay in touch with us, to make it to court, daily survival that goes beyond just normal representation. We look forward to helping her with it. She does have quite a few daily living needs that I am hoping that our office social worker can help her with. And again, I do believe that assistance will increase the odds of her coming to court. I don't want to dive too deep into anything that might be more applicable to that hearing, but what I will say is with our assistance, I do believe the odds of her coming to court drastically increase. I ask the court to factor that in.
Thank you, Mr. Carnes.
It's problematic here because alcohol appears to have been involved in the underlying offense, and then she's not showing up to testing. Given that, I would ask the court to remand.
All right, the defendant was placed on bond back on January 21st by this court. The criminal history includes from 09 a use of a controlled substance, 11 a domestic violence, 13 false report of a misdemeanor, 13 retail fraud third, 14 an attempted retail fraud second, 16 an attempted retail fraud second, 17 an attempted resist and obstruct, 17 a retail fraud second, 18 possession of a narcotic less than 25 grams, 17 possession of an analog, and 23 possession of meth second, 23 assault and battery, and 13 was operating without a license on person, and in 16 a retail fraud third. The defendant was placed on no alcohol and drug testings, and it's alleged that she's failed to appear for 2 of those testings. Therefore, I believe it is appropriate to remand the defendant until we have the hearings. Next to Raymond, jail. Person at the jail, please state your name for the record.
Alexander Ziegel.
All right, this is case number 25-3543 FY. The people of the state of Michigan versus Alexander Barry Zigo. Mr. Zigo, did you have the opportunity to meet with somebody from the defender's office today?
Yeah. Yes, I did.
All right, and you also met or talked with somebody from Community Corrections and gave them some contact information. Is that information accurate?
I think so.
Address on Goodall Street in Durand, Michigan?
Yes.
Durand.
Yes.
Phone number ending in 7053?
Correct.
All right. I have a complaint that alleges between the dates of July 1st, 2021 and March 31st of 2025 in the city of Cadillac and Wexford County. It is alleged in count number 1, which includes the dates of July 1st of 21 through June 30th of 22, that you failed to pay child support. That is a felony punishable by up to 4 years in prison and or a fine of $2,000. In count number 2, which covers the dates of July 1st, 2022 through June 30th of 23, it's alleged that you failed to pay child support. Again, another 4-year felony and or a fine of $2,000. In count number 3 covers the dates of July 1st, 23 through June 30th of 24. Again, another failed to pay child support. Again, another 4-year felony and or a fine of $2,000. In count number 4, that's for the dates of July 1st, 24 through March 31st of 25, that you failed to pay child support. That is a felony punishable by up to 4 years and a fine of $2,000. The total outstanding arrearage as of April 22nd, 2025 was $13,336.26. Do you understand those charges and the potential penalties?
I do.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of an attorney.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set these matters for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that these crimes had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to bound over to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference, and that's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 06 a domestic, 07 a domestic, in 12 no license, 15 a domestic second, and in 16 an assault and battery. The praxis scores him at a risk level 2. And by my calculation, as set by statute, the 25% is $3,334. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. In these situations, I realize my arguments are largely academic. I realize the court is bound by statute. But I would ask the court to still factor in that this gentleman does have strong ties to the community. He does have one of those children now living with him, and an autistic young man, if I understand correctly. His young teenage son is wanting to get home and help take care of that child. I believe some family is presently helping, but he's the primary caregiver and would like to be there. I realize the court's hands are largely tied, but again, this gentleman, if he was given the opportunity, the court found a way somehow to release him on a lower amount, because I don't believe he's going to be able to post that for a variety of reasons. He would do everything he can, take as many side jobs, everything, but even with all the friends and family support, we don't believe they'll be able to chip in enough to get him out pending any bondable opportunities. Thank you.
All right, thank you. Mr. Carnes, I know this is an AG case, but did they ask you to weigh in at all?
They did not ask me to weigh in, Your Honor. I do think the statutory bond is appropriate. Thank you.
All right. Well, as Mr. Hartel mentioned, the court's hands are kind of tied into these situations in front of the court cases or child support cases. The court has to set at least a minimum cash bond of 25% of the amount owing. So the court will set bond at $3,334 cash. With the following conditions, sir, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. All right. All right, thank you. Next, Raymond. Ms. Terry, I brought you back because Mr. Hartel thought you may have been trying to get our attention. Is that accurate?
Yeah, I guess so.
All right, did you need to speak? Did you have a question about something, or did you need to speak with Mr. Hartel?
I didn't mean to miss the drug testing or whatever. I got hit by a car and I was laying in the road for a couple
Miss Terry.
days, I guess.
Ms. Terry, you have the
Yeah.
right to remain silent. I suggest you do that because anything you just said can now be used against you in that hearing that this case was set for. So I guess my question is, are you still requesting a contested hearing? Or do you want to plead to the violation? Or do you want to talk with Mr. Hartel about that some more?
Oh, the plea for the domestic to get it done?
No. A plea to the bond violation.
Oh, yes, yeah.
You want to plead to the bond violation?
Yeah,
Mr. Hartel, did you talk to her about that, or did you just request the contested?
Your Honor, I'll be honest, I didn't initially realize there was a bond violation as well. I might have misunderstood the initial she did in jail. That is not general default way to go, but if she would like to do so, I would feel comfortable with that. She does obviously feel comfortable saying those statements in the court.
Do you want a moment to talk to her before we do that?
It's never a bad idea.
All right.
She had a felony that she was lodged on, then they didn't charge it as a felony.
We're still waiting on that report.
Okay.
That's what I thought we were here for.
Okay. So what I'll do then is, yeah, why don't you join Zoom? I'll give you guys a breakout room and you can talk about what you want to do. Ms. Terry, Mr. Hartel is going to join us on Zoom, and I'm going to put you both into a breakout room so you can discuss how you want to handle the case moving forward. All right?
She's with me at the table.
All right.
All right, it's okay. I'll
Oh, you're fine.
Mr. Carnes.
Terrence, Mr. Carnes?
Nate Carnes on behalf of the people.
All right, and we are here for the docket says a plea and sentence. So what are we pleading to?
You want me to- It's Joanna's file. You want me to say it? You confirm it?
No, I got it. It's, she's pleading to operating while visibly impaired, and we're dismissing operating while intoxicated.
That is entirely correct, Your Honor.
All right, Ms. Brown, have you heard what the attorneys have said the resolution to this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
So it's my understanding you'll be pleading guilty to an added count 2 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $300. In exchange for that plea, the people will be dismissing the operating while intoxicated, which again is also a 93-day misdemeanor, but it has different fines and licensing sanctions. Do you understand that?
Yes.
And is that your full understanding of the plea agreement? Okay. You please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Back on January 4th of this year, were you on probation or parole?
No.
Were you on bond in it at all?
No.
You remember reading and signing the advice of rights form in this case to talk about your rights to an attorney and your rights to a trial?
Yes, sir. I remember the whole night.
All right. Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial? And that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind.
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
I am likewise unaware, Your Honor.
Then Ms. Brown, to the allegation that on or about January 4th, 2026 in the city of Cadillac of Wexford County, how do you plead to an added count 2 of operating while visibly impaired?
Guilty?
Are you sure?
Yes. Sorry, I just had to think about it. I was like,
I'm very nervous, Your Honor.
I understand. In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on January 4th, were you operating a motor vehicle in the city of Cadillac?
yes, sir.
And prior to operating that motor vehicle, had you consumed alcohol?
Yes, sir.
And do you believe that alcohol impaired your ability to operate the motor vehicle?
Yes, sir.
Your counsel believe defendants provided the factual basis in which to accept the plea and that the court rules have been complied with.
Yes, Your Honor.
Yes, I do concur.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Brown, I find you guilty of operating while visibly impaired. Pursuant to the plea agreement, the operating while intoxicated will be dismissed at the time of sentencing, which I assume will be today because I have an assessment. Mr. Carnes, have you received that assessment as well?
Yes, Your Honor.
Does either party have any additions or corrections to be made to it?
No, Your Honor.
I do not, Your Honor.
All right, and then counsel, did you also receive the pretrial program summary from Community Corrections?
Yes, Your Honor.
Yes.
All right. Allocution then, Mr. Harrison.
Well, Your Honor, this is one of those cases that I hate to sound like a broken record, but this is clearly the events of that evening were the product of a mistake made by someone who does not have virtually any experience with the consumption of alcohol. That was the third time in her whole life that she'd ever drank, was that night. And I've watched the video, and I can assure you that she was compliant with the officers, much like she is here today. She was very nervous and even at one point thanked them for being nice to her. So this is not a person that's going out and engaging in dangerous and reckless behavior on a regular basis and happened to get caught one night. This is truly, as the assessment indicates, someone who on one occasion had just enough to be illegal behind the wheel. The PBTs at the jail, the toxilizers were 0.1 and 0.1, 106 and 101. I know I say things like that a lot, and I try to focus the court's attention on, let's not focus on the past. Let's not focus on the regularity of events in this person's life. Let's focus just on the evening in question. In this case, however, I'm actually saying to the court, let's look at the big picture here. Let's look at everything that's going on in her life. She's 25 years old. She works a job and a half. And the only reason I say the half job is that the hours are somewhat irregular. And a second half job that may or may not come to fruition as well. In addition to working at Fox Ford in the detailing department, she does independent car detailing and does house cleaning and, get this, even a little snow plowing on the side. So she's not the kind of person that frankly has enough time to monkey around like this on a regular basis. This was the quintessential eye opener, especially when she realized at her demeanor in court, I believe bears this out. She could theoretically go to jail for this and lose her license, et cetera, et cetera, et cetera. Those things really hit home. I've had to reassure her several times that she will have a restricted license, but she still will be able to drive herself back and forth to work. And that was her primary concern. I think that's very telling here. She didn't say, gee, I hope I have a license so I can go out and party with my friends. She said, look, during the week when I have to go to my regular job, is that gonna be okay with this restricted license? And I had to reassure her of that several times again today. I think this was a case where someone has learned the lesson we want them to learn. That irrespective of your intent, if you drink, you shouldn't drive unless you have some way of knowing magically what your blood alcohol level was. So it was very surprising to her that she was over the limit. She'll know not to do that again in the future. If I could ask for someone in her situation to not be supervised, I would ask for it in Ms. Brown's situation. Based on the fact that most of her life is devoted to being employed. And the substance use assessment says there's no evidence of a substance use disorder, and her prior record is completely devoid of even a mention. Sometimes, Your Honors, you're well aware, we'll get a younger person in that has their first OWI, and you look at, they've had 3 minors in possession, and they had a disturbing the peace. So there's none of that in her past either. Thank you.
Thank you. Mr. Carnes?
Thank you, Your Honor. I really don't disagree with much of what Mr. Harrison said. The one thing I would point out from the police report that does conflict with the feeling okay to drive is she did tell officers when she was pulled over that she was going to her friend's house to sober up. Just a slight red flag there, but then I do acknowledge the community corrections paperwork showing she's been completely compliant while on bond. I'm certainly not asking for jail here, but I do think a brief period of supervision is appropriate, and I'd ask the court to sentence that. Thank you.
Thank you. Was it speeding that brought her to the attention of law enforcement?
Yes, it's a 37 and a 25.
Yeah. Ms. Brown, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No.
So,
Not have to speak at all.
well, I have a couple questions for you.
I'll answer your question.
Oh, thank you. So what have you learned from this?
When did I learn? From
What
this?
have you learned from it?
That I should have not ever drank and drove because I didn't know better. So I regret and I'm embarrassed of my decisions I made.
Do you see yourself acting differently in the future?
Yeah, I've actually been acting different since I got in trouble.
How so?
As in trying to think before I speak or do any other actions. And about how it can affect myself and my future and the people around me.
So you're young. You're in that age group where there's a lot of alcohol around in life and society. How do you plan on handling that in the future?
Alcohol's never really been a problem for me because I grew up watching what it does to other people. And that night I kind of was forcing myself to drink to be able to socialize and be around my friends. And I have found out that that's not really for me and that I should just keep working because that's going to get me the future that I want.
Okay. And what is the future you want?
I want to have my own detailing business and I would like to be able to bring more to the table when I do find somebody to marry and create a better life that way.
Okay. Well, I'll be honest, the level of intoxication concerns me, but I also understand you're 25 and I have an assessment that says you have no issue with alcohol. And as Mr. Harrison said, and as what I heard from you, is that you do understand what impact alcohol has. And I read from the assessment, you've had some family members that have had some issues with it. So I don't believe there's a need to put you on probation, but what I am going to do is I am going to order that you attend the alcohol highway safety education class and the victim impact panel. I think that's gonna be beneficial. And I'm gonna, excuse me, I'm gonna give you 45 days to get that done.
Okay.
All right. There is a $75 crime victims rights fund fee, $50 state minimum fee, $150 fine, $150 court costs, and $150 attorney fee. Mr. Carnes, any reimbursements requested?
Yes, Your Honor, $200 to the Cadillac City Police Department and $100 prosecutor fee.
Ms. Brown, in certain circumstances, law enforcement and the prosecutors are able to recoup a portion of the expense in prosecuting the cases, and drunk drivings happen to be one of those. So that's what those two fees are for.
Okay.
So there's $100 back to the prosecutor and $200 back to the city of Cadillac Police Department. There's 1 day jail with 1 day credit. So because you have sat 1 day, you are entitled to $5 back towards your fine. Any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. Do you have any questions for me about your sentence at all?
No.
I'll need you to go out to the front window where you check in, get a copy of your judgment, make payment if you're able to. If not, get set up on a payment plan. And then you'll need to go downstairs to the district court probation office, which, you know, where community corrections is, where you've been testing. They're at the opposite end of the hallway. So they're going to be the first,
By the door.
yep, first door on your left, or first window on your left. And they'll give you the information as to how to get signed up for the alcohol highway safety education class.
Okay.
All right. All right. Good luck.
Thank you.
Thank you. Mr. Harteller, are we ready to go back on Ms. Terry?
I appreciate that, Your Honor. Thank you.
Sure. All right, court recalls the people of the state of Michigan versus Christy Lynn Terry. Case number 26-215 SM. Appearances, counsel?
Nate Carnes on behalf of the people.
Robert Hartzell for Miss Terry, who joins us through the Zoom from the Wexford County Jail Department.
And I know Ms. Terry and Mr. Hartel had a breakout room. And Mr. Hartel, what are we doing?
Yes, Your Honor, I apologize for the prior confusion, but she would still wish to do admissions to the bond violations.
Is that true, Ms. Terry?
Yes,
Do you understand that you do have the right to have a contested hearing in this case, where the prosecutor would be required to prove to the court that you did in fact violate your conditions of bond? Do you understand that?
yes,
And you wish to enter guilty pleas to the bond violations today?
Yes,
Has anybody promised you anything in order to get you to do that?
no,
Has anybody threatened you in any way?
no,
And is it your own free choice to plead?
yes,
You also understand that as an outcome of this, the court could continue your bond, it could change the terms of your bond, or it could revoke your bond. Do you understand that?
yes,
Mr. Carnes, do you have any objection to taking a plea today?
No, Your Honor.
All right. Ms. Terry, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes,
Then to the allegation that you violated your bond by failing to appear for a drug test as ordered on February 1st, 2026, how do you plead?
guilty,
And to the second allegation that you violated your bond by failing to appear for a drug test as ordered on February 3rd of 2026, how do you plead?
guilty,
Ms. Terry, did you know that as a condition of your bond, you were subject to random drug and alcohol testing?
yes,
And did you fail to appear for a test on February 1st of this year?
yes,
Did you fail to appear for a test on February 3rd of this year?
yes,
Did you know you were supposed to test those days?
no.
Why did you not know?
I didn't have a phone to call.
You didn't what? I'm sorry?
I didn't have a phone to call.
Okay, so you did not check in to see if you were required to test?
No,
All right. Do counsel believe the defendants provided a factual basis in which to accept the bond violation pleas and that the court rules have been complied with?
Yes, Your Honor.
As do I, Your Honor.
As does the court, I find the defendant is in violation of her bond by failing to test on February 1st and February 3rd. And that brings us to what to do about bond, Mr. Hartel.
Yes, Your Honor. Now that we've gone through that, I would still ask the court to consider basically the arguments I made previously for if we were pending the contested hearing, albeit now we're through it. There has been a finding of these violations, but the way I interpreted what she was saying at least wasn't anything malicious, any bad intent or disrespect meant to the court. She just didn't have the resources she needed. And I can't promise that we'll do miracles, but I can't promise we'll try. I know our office social worker, Mr. Henniger, just as I said before, will continue to try to help every client we have, including this young lady right here. And I do believe those added resources hopefully will help make sure she does make it to her future proceedings. I did talk to her a little bit about the underlying case. I won't go into that. It's protected by attorney-client privilege. I believe Ms. Viavento might be the attorney on that file as well. But what I will say is she's very motivated to see that case through. And she's very motivated to come to all court proceedings to see that justice is served. I'll phrase it that way. Thank you.
Thank you. Mr. Carnes?
Your Honor, this, as I said earlier, this was a domestic violence that involved the defendant having consumed alcohol prior to the incident, so it's very problematic that she's not testing. I do note that there's a community corrections note that Ms. Matsky tried to explain the rules, and the defendant said no questions. So it's problematic. She's not checking into tests. Not having a phone isn't an excuse. She can stop into community corrections in person if need be. I would ask the court to remand the defendant. Thank you.
All right, believe I'm reading the same note that you were, Mr. Carnes. It was submitted on one of the program violations form. It says upon sign up, she was uncooperative, did not read the rules. Ms. Matsky tried to explain them verbally. She stated no questions. Is that the note you were reading from?
Yes, sir.
Do we know, has she tested at all?
I don't have that information in front of me. I just have the 2 missed tests.
Yeah, can we call down there real quick? All right, court staff has confirmed with community corrections that Ms. Terry enrolled in testing on the 26th and then has not been tested since enrollment, which would make sense given the dates of those two tests that she missed. Bond was set in this matter at $2,500 cash surety with the conditions that she, among the standards, that she consume no alcohol, she'll be subject to random testing, that she not consume any controlled substances, including recreational marijuana, and be subject to random testing and no contact. We previously went through the defendant's prior criminal history. Mr. Carnes, refresh my memory, was there allegations of drug use in this case?
No, Your Honor, just alcohol.
Ms. Terry, if I were to release you, how are you going to make sure that you're following through with your testing?
Well, I guess I'll stay somewhere that's a lot better than, am I allowed to stay somewhere like that you guys can provide, or should I just go to my friend Ernie Thornton's and then you guys can say that it's okay for me to stay there?
I'm not gonna allow you to go to Mr. Thornton's. That's not gonna happen.
Okay.
So, but the court doesn't have a way to put you somewhere. But my question is, do you remember how you check to see whether or not you have to test?
Oh, yes, so it's the phone, to call on the phone.
It's not how we do it
I
anymore,
think
is it?
There might be more than one option, but I know there's a Facebook is the primary.
Are you aware of the Facebook option?
Oh, no, how do you do that?
Okay. Ms. Terry, this is what I'm going to do. I'm going to continue you on your bond with a bond modification that you enroll in community correction services.
Okay,
All right. So when you get released, you're going to have to come over here to community corrections. And you should be released before they close today. And if I find out that you didn't come over here, I'm going to issue a bench warrant. You're going to find yourself right back where you were. And I suggest
Okay.
you be more cooperative during the process so you can find the appropriate ways to find out whether or not you have to test. Do you understand that?
okay,
You know where the courthouse is, correct?
yes,
All right. All right, the court will continue the bond as previously set. Next arraignment, jail. Thank you. A person at the jail, please state your name for the record.
Jasmine Draper.
All right, this is case number 26-356 SD. The people of the state of Michigan versus Jasmine Joe Draper. Ms. Draper, did you have the opportunity to meet with somebody from the defender's office today?
Yes.
And it looks like you also spoke with somebody at Community Corrections and gave them some contact information. Was that information accurate?
I believe so.
A phone number ending in 0805
Oh, yeah.
and address on Hillshire,
Hill Circle.
Hill Circle.
Yes.
All right, I have a complaint that alleges that on or about February 3rd, 2026 in Cherry Grove Township of Wexford County, It is alleged in count number 1 that you committed the offense of operating with a high bodily alcohol content. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $200 to $700 and or 360 hours of community service, rehabilitative programs, vehicle immobilization mandatory with a prior, and reimbursements for the cost of prosecution and governmental expenses. In count number 2, it's alleged that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle immobilization with a prior, and reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign an advice of rights form at the jail talking about your rights to an attorney and your rights to a trial?
Yes, sir.
Yes. Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request one, please.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I do not show any prior history from Ms. Draper, and the praxis scores her at a risk level 0. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I'd ask the court to consider a personal recognizance bond. I believe that'd be appropriate. As was noted, she has no criminal history, scores 0 on the praxis. She has strong ties to the Michigan area. I know Leroy's a little bit of a drive, but not very far. She's advised me that she'll have no issue coming to all the court proceedings. She is amply employed at FedEx, loading the vehicles, if I understand correctly, which she's very motivated to get back to doing. I believe this is the perfect candidate for a PR bond, even with it being alleged to be a high BAC. I did inform her that the court will almost certainly have some level of alcohol testing. I'd ask the court to consider random testing, although I suspect she might voluntarily still elect to use the daily device because with the hours she works, for a lot of people, it's just cheaper to take that device even at $10 a day. Thank you.
Thank you. Mr. Carnes?
Your Honor, I do think alcohol testing is appropriate here. The PVT was a 0.233, so that is very concerning. But I'm just asking for the alcohol testing. Thank you.
What's alleged to have brought her to the attention of law enforcement?
She was in the ditch right next to Little Mexico where she was.
Okay. All right, given the defendant's lack of criminal history, I believe a personal recognizance bond is appropriate. I also find that she is not a flight risk given her ties to the community. Ms. Draper, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Because of the level of intoxication at a 0.233, I am going to order no alcohol with daily testing, so you'll be required to take that breath machine home with you. I'm also going to order that you enroll in community corrections services. So at some point, you'll be released from the jail today. Make sure you come over here to community corrections here at the courthouse and get signed up for your testing, all right? And I'll note for the record, she was not a yes. So thank you. Next arraignment, jail. A person at the jail, please state your name for the record.
Jesse Parent.
All right, this is case number 26352FY, the people of the state of Michigan versus Jesse Tyler Ryan Parent. We're here for an arraignment. Mr. Parent, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
I believe so. Should have been.
An address on Cranberry Lake Road
Yeah.
and a phone number ending in 35.
Yep.
And did you also have the opportunity to meet with somebody from the public defender's office today?
I did.
I have a complaint that alleges that on or about February 3rd, 2026, in Wexford Township of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assault, resist, or obstruct. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and consecutive sentencing may apply if it happened in a place of confinement. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I am requesting a private attorney, but I spoke with the public defender, and I believe he said that I could request my private attorney, but then for right now, since he's present for this hearing, that he could kind of guide me and speak today.
So
If I may translate.
yeah, I think you go ahead. I think you know what he's saying, but go ahead.
Yeah, he
Yes,
knows what
Ron.
I'm saying.
No, if you understand, then you understand, Your Honor.
So what I think you're saying is that you want to hire your own attorney, but you want the public defender to speak for you today at the bond hearing.
Yeah, yes.
All right. The court will note that you plan on hiring an attorney, will enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered bound over to the circuit court to stand trial. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that procedure?
Yes, Your Honor.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show any prior criminal history for Mr. Parent, and the praxis scores him at a risk level 1. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. What I would ask the court to consider is a personal recognizance bond. I do believe that would be appropriate. As was noted, he has no prior criminal history. He scores very low on the praxis. He advised me that he is self-employed, works quite a few hours doing that, largely out of the Traverse City area. He also lives in Harrison, has lived there for quite a while. Even though neither of those is our immediate area, I mean, I know I visit both those areas on a frequent basis, and he's advised me that he has no foreseeable reason he wouldn't be able to make it to court. He is highly motivated to retain his private counsel and things of that nature. I won't overly allocate due to that, but again, I do believe PR is appropriate. I would ask the court to adopt it. Thank you.
Thank you, Mr. Carnes.
Your Honor, I don't object to a PR bond in this case. Thank you.
All right. I do note the defendant lives in Harrison. However, the court lived in Harrison for a few years and made the drive between Harrison and Cadillac every day. So it's as boring as that drive might be. I realize it's
Yeah.
doable. So
Yes.
I will authorize a personal recognizance bond in this matter with the conditions, Mr. Parent, that you appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, you are not to act in any threatening, intimidating, or harassing behavior. All right. So at some point today, you're going to be released from the jail. Before you're released, you're going to get your next court date. Make sure if you hire an attorney that you give them that court date, because until they actually file an appearance with the court, they're not going to receive anything from us. Now, if something happens that you can't hire an attorney or it just doesn't work out, and you want the court to appoint an attorney, go ahead and contact us and we'll make that paperwork happen to get the referral over to the defender's office. All right.
Okay.
All right. We'll see you next week.
Okay. Thank you.
All right. Thank you. Thank you, jail. You are free to leave. A sheet has been turned in, so the matter is being set for a final pretrial. Just a reminder that you have to get your fingerprints taken. Okay.
Okay.
All right. Thank you. You're free to leave.
All right, thank
All right, court next calls the people of the state of Michigan versus Jocelyn Nicole Dean, case number 2615 SM. Appearances, counsel.
Lisa Dahl appearing for Nate Carnes for the people.
Thank you, Honor Taylor and Anna Fervento. On behalf of Ms. Dion, who joins us from the Osceola Jail.
And we are here for a pretrial, but it looks like there's a resolution. Is that accurate?
Yes, Your Honor, people have offered that if defendant would plead guilty to domestic violence, there would be a appealable agreement for a 4A referral.
Is that accurate, Ms. Fervento?
Yes, Your Honor.
Is she currently in the Osceola court for her absconding warrant?
Your Honor, it's my understanding that she is serving a sentence in Osceola that will conclude on March 20th. And I believe she has one other matter she needs to take care of as well. She would be able to grant more info on that. Sorry, the connection's very echoey, so it's a little hard to understand. So we're fine with if we need to set this out temporarily for sentencing, but we would be ready to move forward today if the court was as well.
Is she serving the sentence for her probation violation?
I don't know what she's serving on in Osceola, Your Honor. I just know that she says her out date for Osceola is March 20th and that she's been sentenced in that matter.
Ms. Deem, are you under sentence for a probation violation or something else?
Probation violation.
Probation violation? Are we able to get a record with the echo?
Yes, just harder.
All right. Counsel, given the 4A, I don't want to take the plea today. What I'm going to do is I'm going to refer this to the public defender's office. The probation office for a PSI. It does not bode well for her that she had a warrant for absconding probation, and we want to give her 4A. So we're going to send this for a PSI before I agree to do a 4A.
Thank you, Judge.
Ms. Diem, how long are you in Osceola County? When's your out date?
Until March 20th. It was March 20th.
All right. Okay, so somebody from the district court probation office will be in contact to do a PSI for you, all right?
We have sent a PR since the 15th, and she sent that from our court. Okay.
The court is going to revoke the PR bond, given that she's currently sitting a jail sentence. Well, it doesn't matter, 'cause she's not gonna get credit anyways, because she's under sentence.
Oh, yeah.
All right, I will keep the PR bond in place.
My bad.
All right, thank you, Osceola.